9 and 7 a.m. My name is John Allison. I'm the designated hearing officer for this particular matter. Supreme Court number 0062720. I'm a partner at the law firm of Carpenter, Lips, Leland. We're here today on the matter of the Secretary's intent to remove 2 members of the Montgomery County Board of Elections. Before we get started, I have had an opportunity, as some of you may have witnessed, to briefly leave the room with counsel for both parties and essentially went into another room just to talk about the ground rules that I'm going to talk to you about right now. This is an administrative hearing. We're not in a court of law. We, of course, have a court reporter here in order to take everything down and to make sure that we have a proper record of this proceeding. I would ask all who speak today to please respect the court reporter, speak slowly, speak clearly, speak one at a time. I certainly reserve the right, if it becomes difficult for her to stop people, we'll cut them off at the pass and make sure that the record gets made properly. I also reserve the right to keep this hearing moving. I would like to stick to what is in front of this hearing and what has been brought to us via this notice of intent to remove. I want to be clear that I do not have authority as a hearing officer to decide this matter. I have the authority to hear the record that is made today, to look at the law, and to look at the facts, and to make a recommendation based upon what comes in the record today. By way of order of this proceeding today, we will first give the state the opportunity to make a statement about its case, and then turn it over to Mr. McTigue to make his case and to put his evidence on the record. I would ask at any time that the first time you speak, whether you're an attorney or a witness, please state your name, spell your name, give all that basic information slowly for the court reporter so we have a record. Question from counsel on either side before we begin? Hearing no questions?
We have a couple of preliminary motions to make. Those now, wait a second.
Sure.
Okay.
Mr. McTigue?
Yes. Don McTigue on behalf of Mr. Lieberman and Mr. Ritchie. Mr. Hearing Officer, we have a couple of motions to make. First is a motion to dismiss based on the notice letter for the hearing today does not clearly state what the grounds are for a proposed action, disciplinary action. And what I'm referring to is that 2 things. First of all, I think as we all know, there are 2 events that form the factual background for this case. One is a meeting on the 17th of the Board of Elections in the morning, which a motion was made resulting in a tie vote. And then there was subsequently a letter from Mr. Schroeder directing the board or ordering the board to reconvene a meeting in the afternoon and to rescind the action taken by the board in the morning. So it is not, and of course then the board reconvened, but the action wasn't rescinded. So it's not clear though from the notice letter for this hearing whether the alleged problem or misconduct or what have you is based on the original motion that was made or based on the failure to rescind or based on both. If you read the notice letter, it is not clear what we're talking about here. And in my mind, those are 2 distinct issues. Second, the notice letter does not indicate whether it's alleged that there's neglect of duty, misfeasance, nonfeasance, or malfeasance, which are the statutory grounds for taking action against a board member. So based on that, I request that the case be dismissed, or at least that it be postponed until a more detailed letter is provided as to the basis for the proceeding. Second motion, Mr. Hearing Officer, is to continue the hearing to allow additional time to prepare, which, first of all, would obviously be necessary if you grant the first motion, but also, even without granting the motion, there is a need for you to prepare. This clients were notified on, I think, Friday, late Friday afternoon, regarding the hearing that is being held today. That is not enough time for counsel to prepare to interview witnesses, potential witnesses other than two clients, regarding the background of this case, and to try to seek the attendance of witnesses here today, beyond, again, my two clients. So
May I ask, were there in fact other witnesses that you identified who were not able to make it here, given the fact that notice came on Friday and now it's Monday?
Well, I think that there would be board employees who were meeting with the two Republican board members as well, and I think also there may be members of the Secretary of State staff that we would want to have to interview and ask questions as well regarding the pronouncement of the directive number 35, and then the subsequent action taken with Mr. Dan Schroeder's letter to the board.
Okay. Those are your only two motions?
Yes.
Okay. Any response from the state?
Yes, Your Honor. Rich Coglanese, C-O-G-L-I-A-N-E-S-E, on behalf of Secretary Husted. Let me start with the charges themselves. The exhibit book that the hearing officer, Mr. McTigue, had in front of them, Exhibit 5 actually has the letter as to the reasons that we are here. And it is clear from the letter itself that the reason that we are here is because of the failure to follow Directive 2012-35. So that in response to Mr. McTighe's question, was it because of the morning meeting with the vote in contravention of 2012-35, or the afternoon meeting and the failure to rescind the action that violated Directive 2012-35? The answer is both. Further, Mr. McTigue asked the reason that they are charged under the statute, and the letter itself in the first paragraph says, the second sentence, "You therefore leave me no choice but to begin the process necessary to remove you as members of the Montgomery County Board of Elections for nonfeasance pursuant to 3501-16 as demonstrated by your actions today." So it is clear that it is a case of nonfeasance under 3501-16. There is no reason to dismiss this case. It is clear what the charges are. It is clear in the letter what the statutory authority is and what the problem was. Furthermore, as Your Honor mentioned in the beginning, the role of a hearing officer in one of these cases is to hear the issues and to make a recommendation to the Secretary of State. There is nothing in that role that would include a flat-out dismissal of charges. As it relates to the second motion that Mr. McTigue made to continue the hearing, we would oppose that and think it is unnecessary. The only issue before the tribunal this evening is, are Mr. Ritchie and Mr. Lieberman, did they act in contravention of 2012-35? There's no reason for a parade of witnesses, for interviews for folks from the Secretary of State's office. It's a very, very simple factual and legal analysis in the sense that this is what the director said, this is what the gentleman did, and should then, as a result of that, you make a recommendation to the Secretary one way or the other. We don't need to have people from the Secretary of State's office, other members of the board testify. I think the facts in this case probably would be agreed to, that Mr. Ritchie and Mr. Lieberman initially voted not to follow Directive 2012-35, and then, as a result of the afternoon meeting, did not rescind it. So we see no reason to delay this hearing. After all, Your Honor, we are less than 80 days out from a presidential election, and it is necessary to make sure that the Board of Elections, if Mr. Ritchie and Mr. Lieberman were to be removed, have a full complement of board members.
Thank you.
Just my only reply to one thing that Mr. Cognity said was he indicated that the evidence shows that the two Democratic board members voted to not follow the directive. That is actually not true. What the evidence actually shows is that the motion was to follow the directive. And that's the wording of the motion. It was set forth twice in the transcript. And therefore, they actually voted to follow the directive. What we have here is a difference of interpretation as to what the directive, or what the scope of the